Section 9. Case Study, Contract Classification in Real Transactions, Applying Contract Classifications to Real Estate Practice. In the previous sections, we examined how contracts are classified based on their legal status and structural form, including valid, void, voidable, and unenforceable contracts, as well as bilateral, unilateral, express, and implied agreements. While these concepts may appear straightforward when discussed in theory, real estate transactions often present situations where the classification of a contract becomes unclear or disputed. In everyday practice, misunderstandings about contract classification can occur when parties rely on informal agreements, misunderstand the legal status of a contract, or fail to properly document the terms of a transaction. These issues frequently arise in competitive markets where negotiations move quickly and parties attempt to secure deals before fully documenting the agreement. For real estate professionals, recognizing how contract classifications apply to real-world situations is an important part of risk management and professional responsibility. Misclassified agreements can lead to disputes, failed transactions, and potential legal liability for the parties involved. Misclassified agreements in real estate deals. Misclassification occurs when parties incorrectly assume that a legally binding contract exists when it does not, or when they believe an agreement has no legal effect even though it may be enforceable. These misunderstandings can arise when parties rely on incomplete documents, unsigned contracts, or verbal assurances rather than finalized agreements. For example, a buyer and seller may verbally agree on the purchase price and closing date for a property. Both parties believe they have reached a binding agreement, but no written purchase contract has been signed. Because the statute of frauds requires contracts for the sale of real property to be in writing under ARS Parv 44-101, the agreement may be considered unenforceable despite the parties' verbal understanding. Another example may involve a contract that contains all required elements but was signed under circumstances involving misrepresentation or undue influence. In that situation, the contract may actually be voidable, even though one party believes it is fully enforceable. Real estate professionals must understand these distinctions because misclassifying a contract can create unrealistic expectations for clients and lead to serious disputes when the transaction fails to proceed as expected. Reliance on verbal agreements. Verbal agreements often create confusion in real estate transactions. Parties may believe that a handshake agreement or verbal promise is sufficient to secure a deal. While verbal agreements may be enforceable in certain types of contracts, real estate contracts generally require written documentation to be legally enforceable. Imagine a scenario where a seller verbally agrees to sell a property to a buyer for $525,000. The buyer believes the property is secured and begins making arrangements to move, while the seller later accepts a higher written offer from another buyer. The original buyer may feel that the seller acted unfairly, but without a written agreement, the original verbal arrangement may not be enforceable. This situation highlights why written contracts are essential in real estate transactions. Written documentation creates clarity and ensures that the parties understand their rights and obligations. Without written evidence of the agreement, courts often cannot enforce the transaction. Consequences of improper documentation. Improper documentation is one of the most common causes of real estate disputes. Errors may occur when contracts are incomplete, improperly signed, missing required disclosures, or incorrectly modified after execution. For example, imagine a situation where a buyer and seller sign a purchase contract but later agree to change the closing date through a verbal conversation rather than a written amendment. When the buyer fails to close on the original date, the seller may claim the buyer is in breach of contract. The buyer, however, may argue that both parties agreed to extend the deadline. Without written documentation of the modification, resolving the dispute becomes difficult. Courts typically rely on written evidence to determine the intent of the parties. This is why contract amendments, addenda, and modifications should always be documented in writing and signed by all parties involved. Proper documentation protects both the clients and the real estate professionals involved in the transaction by creating a clear record of the agreement. Brokerage compliance lessons. Real estate brokers and salespersons play a critical role in helping clients navigate the contract process. Because licensees regularly assist with contract preparation and negotiation, they must follow professional conduct rules that require careful documentation and communication. Under AAC R4-28-1101, licensees must exercise reasonable care and diligence when assisting clients in real estate transactions. This includes communicating material information, ensuring that documents are properly completed, and avoiding actions that may mislead the parties involved. Broker supervision rules under AAC R428-1103 also require designated brokers to maintain oversight of transaction files and ensure that licensees follow proper procedures when handling contracts. These rules help protect consumers and maintain professional standards within the industry. From a brokerage perspective, proper contract classification and documentation are essential components of risk management. By ensuring that agreements are properly written, signed, and stored in transaction files, brokers help reduce the risk of disputes and regulatory violations. Online discussion. 1. Question: why can relying on verbal agreements create serious problems in real estate transactions? Answer: verbal agreements often lack clear documentation and may not satisfy legal requirements such as the statute of frauds. Without written evidence of the agreement, courts may be unable to enforce the transaction, even if both parties believed they had reached a deal. 2. Question: how can improper documentation lead to disputes between buyers and sellers? Answer: when agreements or modifications are not documented in writing, the parties may have different understandings of what was agreed upon. Without written proof, resolving the disagreement becomes difficult and may require legal intervention. 3. Question: why are brokerage supervision and documentation requirements important for contract risk management? Answer: proper supervision and documentation ensure that contracts are correctly prepared, signed, and stored. These procedures help prevent disputes, protect clients, and ensure compliance with real estate regulations and professional conduct standards.